When you're lost in a world of legal war, and you don't know which way to go, there's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend.
Welcome back to HR's Best Friend, our podcast for HR professionals and business leaders who want to make sure they stay compliant, don't get in trouble, and keep their employees happy. D. Scott Crook is the Utah employment lawyer. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He's the managing partner of Crook Legal Group. Scott is only licensed to practice law in Utah and Idaho. He is not giving specific legal advice. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney. Preferably this attorney, Scott. So my dad and I have both been super busy and both have gotten sick a few times, so it's been a while since the last episode, but we're excited to bring this one to you now. In this episode, we're going to talk about a lawsuit for racial discrimination. We're going to talk about SpaceX and a sexual harassment claim that was brought against them, and we're going to do illegal, actionable, immoral, or normal with both of those cases. And then we're going to answer some questions from Facebook and Reddit. Anyway, hope you enjoyed this episode. Thanks. All right, welcome back to HR's Best Friend. It has been a little while. We both have been sick and or busy, but we're finally back in the studio, ready to record. Hi, Dad.
Hello, how are you?
You know how I am. I'm doing great.
Good.
I'm doing great. So we got some good stuff today. Going to do some illegal, actionable, immoral, or normal with a couple of discrimination lawsuit stuff that's been in the news. And then we're going to answer some anonymous questions from HR pros on Reddit and Facebook. So let's begin with our illegal, actionable, immoral, or normal. So the first one comes from, we just apply all of these to Utah. So we're going to assume this happened in Utah, but this was an actual thing that happened in Pennsylvania. There was a black individual who was hired to the hospital's transport unit named Ferguson in December 2022. He had a good review in early 2023 and got a raise. And this is all stuff that's in his lawsuit. So we're just going by what was in there, assuming for the sake.
Assuming it's true for purposes of the questions, right?
Yes, exactly. Anyway, so his employment was going very smoothly and positively until March 20th. On that date, Ferguson said, the lawsuit says that a coworker named Elaine Keenan, who was described as an older white woman, was asked about a doll she was making and replied that it was a monkey. She then held up the unfinished work and said, "Look, it's Caleb." And the name of the individual we're talking about is Caleb Ferguson, right? So she made what most people would interpret as a racial remark. So Ferguson's lawsuit said that several other workers heard the comment and that his supervisor, his name was Joseph. Oh man, I don't even know. We'll just call him Joseph. Was either there or shortly heard about it from Ferguson and others. The lawsuit said that Ferguson was stunned and assumed someone would reprimand Keenan, given how outrageous the conduct was. He was wrong. So the first part of this, what we just read here, any illegal, actionable, immoral, or normal things to pick up on.
So interestingly, obviously, in my view, it's immoral to do things that are racist.
Yes. That is an official policy of Crook Legal. That's an official policy statement of Crook Legal. We are against racism.
Yeah. It's hard to know if the person who is doing this, I mean, just from the allegations, whether she actually knew that it was racist, but I think most people would probably catch on and think that it was probably not a great thing to do and that it may have some racial overtones. So it's clearly, in my view, immoral. I just don't think that, you're either intentionally trying to do something provocative, or you are ignorant in a way that is sort of um unbelievable. I guess is the way to do it. So yeah, it's immoral at this point, though. And most people will probably be shocked by this. It's not really actionable because it's certainly something that HR, human resources, should get involved with and stop. But when I'm thinking of actionable, I'm thinking of, do you really have a lawsuit yet? And the answer is probably not, because if it's an isolated incident, and it gets corrected, or even if it's not corrected, but it's an isolated incident, then that probably doesn't rise to the level of an actionable claim. In other words, you can bring a claim, and particularly if it's not a supervisor. Um, if it's just a co-employee being stupid, doing something that's racist, definitely not a good thing. Definitely something that should be corrected, but it probably won't rise to the level of a lawsuit yet. Simply
Okay.
because it has to be um, a, an environment that is more um, discriminatory than a single incident.
Okay. Okay. Well, then, moving on, because this escalates. So
Yeah.
a week later, Keenan, so this is the older woman who had done this with the doll, said in front of coworkers that she had finished the doll, held it up, and said, "Everyone meet Caleb." Okay, so Ferguson was horrified, extremely upset, and shocked, according to the lawsuit. Ferguson immediately went to his supervisor to complain vehemently, insisting that Keenan's comments were humiliating and that monkey was a racial slur. The lawsuit said that the supervisor did not react in any meaningful manner, did not apologize for Keenan's behavior, and simply said that he would handle it. By the following week, no action had been taken against Keenan. The lawsuit said, and nobody had spoken to Ferguson about the incidents. In fact, Keenan was working on a new doll. So now, where are we?
Well, it is interesting. Something I didn't mention in response to the first one. If I'm not Keenan, but Ferguson assumed that after the first incident that someone would do something, that's not enough. You should go and talk to somebody. Maybe the supervisor didn't notice. Maybe wasn't there, because it's not clear from that. So when he
Right.
does go and he complains, obviously human resources should do something. Um, the interesting thing about your description is that Ferguson assumes that Keenan must be disciplined, right? There must be some kind of discipline, and he should know what's happening to Ferguson. That's not necessarily true. Um, uh, Assuming when somebody goes to report, you have to remember, just because you were insulted or argue, clearly have a legitimate complaint, doesn't mean you're going to find out exactly what happened to the person about whom you've complained. Um, Generally, just like if you get disciplined, you don't expect the whole world to know what your discipline is. Um, Most employers should be keeping disciplinary matters confidential. So it's possible that she was disciplined. She may have been been given a write up. He wouldn't necessarily know that. Now, is it good practice not to tell him that, hey, we've taken your complaint seriously, and we have taken some measures? That's not a good idea not to do that.
Right.
You should tell them. And so, again, this could rise to the level of discrimination, but again, it's a second incident involving the same doll. It still may be isolated enough that it's not a problem yet for actionable
Sure.
pieces.
Okay. 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 And then the last piece of this. So on April 2nd, which is
It's after
which is
March.
yeah, it's just a yes, just after March. It's just a couple weeks after this. About um, Ferguson and another employee got into a heated disagreement over a work issue, and Ferguson was summoned to his supervisor's office for a reprimand. The supervisor repeatedly talked over Ferguson and appeared to want to escalate the encounter. Eventually, the supervisor picked up a phone and called the hospital security, telling them that there was a man in the unit acting crazy. Ferguson was told the next day that he was suspended and he was fired on April 6th. The hospital did not respond to messages seeking comment. So that's the final piece of this specific story. So this one doesn't really, I mean, it's not. There's no racial, at least directly, parts to this. But you're the lawyer, so is there anything in here that, because of what has already happened, that makes this bad, like illegal, actionable, immoral, or normal? Anything in here that's...
Well, so first of all, if you look at everything in isolation, in other words, if this was just an incident that had not occurred after the preceding incidents regarding the knitted monkey,
Right.
there would be no question that um, what the supervisor did was totally appropriate. If someone's in a heated discussion, they get called in, they get reprimanded. Now, was the was the supervisor professional? If it's true that he yelled over Ferguson, that's not good. But doesn't necessarily make it an actionable thing. People, you're not entitled to a jerk-free environment. Sometimes supervisors yell at you. That's not a... you don't have protection against that. In the context of the of what happened before, there's very little, unless you could show that there's some relationship between his complaint and the discipline that occurred later. That's really not, that wouldn't be something that would be actionable at all. The fact that this occurred shortly after that, there may be some inference that it's related to his complaints, but that's going to be a big leap. And that's something that a lot of employees sort of have a misunderstanding about. And that is that, well, if I complain about something, I can never be disciplined again, or that somehow by complaining about something, it immunizes me from being disciplined for bad behavior. That is not true. Even in the instance where, let's say that this was totally related to his complaint. In other words, that they got in an argument during the complaint about what Keenan had done. And he was yelling at his supervisor or something, or saying, well, I can do whatever I want. Well, you could still be discriminated. I mean, not discriminated, disciplined for acting poorly in making the report. If it's something that most people would be disciplined for, just because you've suffered discrimination, in other words, does not give you the right to then break all the other rules. So that's what I would say. If there is, obviously, if there is some connection and it is retaliation, then you might have a claim, but that's a big leap.
Right. Yeah, and I just saw the news report. I didn't see the actual lawsuit. So maybe it does talk about more, but just based on what I read, it didn't seem to be related. So anyway, it's all interesting. Obviously it doesn't sound like a great work environment if all of that's true for Caleb Ferguson. But anyway, interesting. Okay.
Yes.
Moving on. So this is regarding SpaceX, the famous SpaceX. So so the plaintiff isn't named here, so she's just called plaintiff, which is a lovely name. Plaintiff.
Yes.
The plaintiff was hired in August 2017 as a production coordinator. She initially reported to Juan Hernandez, so that was her supervisor. As part of her numerous one-on-one meetings with Hernandez, the plaintiff expressed her interest in scheduling, which is a type of position apparently that I think is more technical than what it sounds like. But she had interest in scheduling and was assigned additional tasks and projects by Hernandez to prove her value and dedication to him and the role. Hernandez also informed the plaintiff that she would need to take courses in Microsoft Project, SQL, Python, and VBA to further develop her skills for SpaceX and the scheduling role. So the plaintiff did enroll in all those classes so she could perform for SpaceX, and get the scheduling role, and informed Hernandez that she had enrolled in those classes. So as a result of her performance in the additional tasks and projects assigned to her by Hernandez and the plaintiff taking the courses, Hernandez promised the plaintiff that he would promote her to a scheduler as soon as the opportunity or headcount to expand the team became available. I'll pause right there just to point out we're assuming this is in Utah. It's not, it's in California, but just for our purposes, we're assuming it's in Utah, and we're assuming that it's all true for our purposes. Okay, so that's happened. So Hernandez promised the plaintiff that opportunity. Okay, now, alongside doing her full-time job, she also enrolled in an after-work master's degree program, to get, to help cement her getting more opportunities at SpaceX. She graduated in May 2018 with a master's in business analytics, and then 2 scheduling positions became open on Hernandez's team. However, despite plaintiff doing everything asked of her and being promised the promotion to scheduler, Hernandez refused to even allow her to apply for the positions, and instead Hernandez immediately hired 2 male external candidates to fill the roles. Hernandez even created space on the main level so the male schedulers could be close to him and his desk. However, when plaintiff had asked for the same move so she could be closer to Hernandez and the team, Hernandez refused the request and left plaintiff isolated from Hernandez and the team. It became abundantly evident, this is what it said in the actual lawsuit, it became abundantly evident that Hernandez was discriminating against plaintiff because she was a female and giving preferential treatment to males. So in Utah, is what was just described illegal, actionable, immoral, or normal?
Oh, there's a lot in there. So it could be normal. It could be abnormal. It could be
Well, if
it
we're
could
just getting
be
specific, if a supervisor promised,
go ahead. Sorry.
if a supervisor promised to promote you, and we're assuming that's what really happened here. It doesn't sound like that was written or anything, but she had a verbal promise from him saying, yeah, if you do these things, I'll promote you to scheduler. And then when she did those things and the roles became open, he hired 2 external male candidates. So is there anything in that?
Well, the answer is maybe. Okay.
Okay.
So assuming your facts, assuming if you promise that if you promise that I do X and Y, that I will then promote you to this position, and I do X and Y, and then you don't promote me, that's a breach of contract. And the reason for that is, even though it's an at-will, we're in an at-will state, and even though you can terminate a person for any reason or no reason at all, that does not affect other aspects of your of contractual relationships and how they're formed. So just like if you were to receive a promise, okay, you work for me, and if you do, I'll pay you $10,000. You have to pay that person $10,000. Now, in the future, because of the way at will works with the way we perform employment contracts, if you just have an ordinary at will relationship, if then after you've earned the $10,000, then your boss comes to you and says, "Oh, I'm sorry for that same work. Now I'm going to pay you $5,000." If you continue to work, now you have to be paid. I mean, you've agreed to that modification of the contract. Same's true here. If someone says you do X and Y and you will get Z, and you don't get Z if you do X and Y, that's a breach of contract and it's actionable. Okay. The problem
So,
is the way the
well, I
description
was just
is in this complaint is that he said, if you do this and you prove to me as proof to me that you would be a good scheduler, then I will give you that. That's kind of ambiguous, because you could say, well, maybe she did do it, but then she got C's and D's in her courses, or she didn't perform well. Well, then That's not proof that she could do well as a scheduler, and therefore he didn't break any promise to her, and therefore there's no contract. That's why I hesitate a bit. Then there's
Gotcha.
the other elements, though. If she did X and Y and he didn't hire her, but instead hired males, well, not only do you have a breach of contract, you have potentially gender discrimination. But you'd have to show that the reason why he didn't hire was because of her sex and their sex, not something else. But there's a presumption there. There would be a presumption that it was because of sex, even though it might be for some other reason. Maybe the reason he did it is because she was not a nice person. He didn't like being around her and he liked these other guys better. That doesn't have anything to do with sex. That has something to do with personality. So there's a lot
Okay.
in that.
Yeah, there is. Just quick, I don't want to spend too much time on this question, but if like in the course of this like how would this work? Like would a judge say, "Did you promise that?" And then would this person say, if the person said no, I didn't do that, then
Well, that's
like how would that actually play out
well, the thing
as a
is that
non-lawyer?
if well, I mean, you're asking a litigation question, and the litigation question is this: if you do in discovery discover that he did make those promises, and there's no question that he made the promises, maybe he admits to it, then you probably don't have to go to trial. You file what's called a motion for summary judgment. All the facts are all the relevant facts show that he did make the promise. Then the judge will enter um, summary judgment against the employer for those purposes. Now, there's a whole lot in that, and I'm just being
Okay.
oversimplified. But yeah, but let's say he says, no, I didn't make the promise.
Yeah.
Well, that's what a trial's for.
Okay.
So then a jury or a judge hears the evidence and they decide who's more believable.
Gotcha. Okay. That's interesting. Moving on to the second part of this, because this complaint is long. At
Yes.
least I mean, I don't read. This is like the first actual complaint I read, but there was a lot in there. So, okay, January 2019, there was a business restructure. The plaintiff now reports to Brooks. Okay, the plaintiff complained to Brooks about her not receiving that scheduler position, and she was afraid she was going to lose her job. She said she may want to find a job outside of SpaceX where she wouldn't face discrimination. Brooks discouraged her from leaving while commending her abilities. She applied to a different job within SpaceX. She got an offer. The salary was lower than she expected. Brooks promised to promote plaintiff to a scheduler with better comp than she was being offered if she stayed on his team. Shortly thereafter, in June 2019, Brooks organized an event for the team to travel to SpaceX's work site somewhere else to watch a rocket launch in person. During a one-on-one before the trip, Brooks informed the plaintiff that there were limited spots available in the van that was scheduled to take them. And because of the limited space, Brooks asked plaintiff how she planned on getting to the launch. When the plaintiff said she was going to drive up separately, Brooks insisted that he accompany her on the drive. The plaintiff was taken aback by Brooks's insistence and did not want him to accompany her, but plaintiff felt pressured so she agreed to Brooks' demands, and she was her boss. In that segment of what I just said, is there anything there that is a problem? Is it illegal, actionable, immoral, or normal? Can a boss say, "Oh, there's not going to be enough room in the van. How are you going to get there? Oh, I'm going to drive. Oh, well, I'm coming with you. You're going to drive me too."
So, can a boss say that? Certainly a boss could say that. Is that something that I would ever encourage anyone to do? No. Is
Maybe
it
we need to
against the
add.
law?
Maybe we need to add like illegal, actionable, immoral, normal, or wise.
Yeah, well, it's definitely not wise. There isn't anything really illegal about anything that was described, and I can't tell right now if I would say it's immoral. I think it's not a good practice, and telling somebody they have to, take you along if you're their supervisor, I don't know why you do that except for what's going to happen in the
Right.
next
Okay. We're
allegation.
assuming it, and we're assuming it's true for our sake.
Yeah, right.
Okay. Now, 3, plaintiff agreed to carpool with Brooks to the launch site. During their commute to the launch, Brooks began dropping hints to plaintiff that he was protected at SpaceX, saying that he was directly recruited by a vice president at SpaceX, and that they had a connection with, well, Brooks and this vice president had a connection because they were both Englishmen. Without saying it directly, there was an implication behind Brooks's words, as if he was insinuating to plaintiff that he would be protected by the vice president, which plaintiff would later discover was setting her up for Brooks's next action. Because of the length of the commute, plaintiff had to stop to charge her Tesla. While they stopped at a Tesla supercharger, plaintiff went to the bathroom, but before leaving, she explained to Brooks how to release the charger so they could quickly be on their way and get back on the road when she returned from the bathroom. When plaintiff returned to her car, she saw that Brooks had not released the charger and was still standing outside next to it. As plaintiff approached the car to release the charger, Brooks grabbed the plaintiff by the waist, pulled her against his body, and kissed her without her permission. Plaintiff was in utter shock, as she had in no way ever given any indication that she had any interest in Brooks or that his advance was welcome. Illegal, actionable, immoral, or normal?
It is illegal, actionable, and immoral. So like we discussed about the monkey incident, usually this is different in kind than that, because in the monkey incident it was a coworker and it could have been an isolated incident. In this case, this guy's a supervisor,
Right.
and it may have been an isolated incident, but there was physical touching and an actual sexual conduct, and to the extent that kissing somebody, grabbing them, pushing, and that the fact that it's a supervisor escalates everything and makes it a huge problem, because the fact that a supervisor means that SpaceX, if this is true, is vicariously liable for everything that happens. Meaning, and it's automatic because it's a supervisor. Okay. And secondly, the fact that there was physical touching escalates this to being something that, and if it's unwelcome, again, is immediately a problem. This would never be okay. Maybe she doesn't suffer any damages, meaning she doesn't get demoted or anything. She doesn't do anything, but the law doesn't care. There's damages from compensatory damages, which would be emotional, or, it's got that component. This is an actionable claim. And most lawyers who would hear this, assuming it's all true, would take this case in a minute.
Yeah. Okay. So there was a lot more in this case. It gets pretty hairy. If our audience demands it, we can go further into it in a different episode. We're going to stop it there, but it does get very, very, very sticky. But anyway, thank you for your analysis. Let's move on to our anonymous questions. So let's knock these out. I've got a few of them. So this was an anonymous question on Facebook. What are your thoughts on offering a severance as an alternative to a PIP, which is Performance Improvement Plan? Yes, the HR people will all know that.
Yes, right.
I'm familiar. I've never been on one, but I am familiar with that. Leadership. Okay, so leadership is asking me to consider. This specific employee has been coached on performance many times. At one point, we had to bring in an external resource to mediate and coach. At this point, management wants to issue a final formal PIP, but they are not confident the employee can actually improve. They want to offer a good faith opportunity for improvement, but realistically know it is likely to end in a termination. We're discussing potentially offering a 3-month severance instead of the PIP, completely up to the employee which route they want to take. They see it as sparing the employee the extended torture of being on a PIP, and continuing to underperform. I'm trying to consider all sides before offering a recommendation. So, what are your thoughts on this?
My thought is that's perfectly acceptable. And sometimes, and it's something that I would recommend to a client in a minute. Certainly, if they're trying to improve.
Did you hear that loud car that
Yes.
drove by? Yeah. Oh, there it goes again. It's anyway, keep going. Sorry.
So the fact that they're trying to help the employee, they're trying to move them along in improvement. It's likely that they're not going to improve in their performance. Doesn't seem like it's a disciplinary issue. Maybe it's just a capacity or competency issue. If it is torture for the employee and the employee is likely to fail, then what's going to happen is the employee is going to ultimately end up losing their job, his or her job anyway. And so offering as an alternative severance is actually a generous offer. It can also allow people to feel better as they leave because you can negotiate, as we've discussed several times before. In other videos, you can discuss things that you can do to assist the employee in their search for a job. So,
Right. Okay.
yeah, that's a good idea. It's
Okay.
not a bad idea.
Awesome. Okay, next one. So this is a fully remote company. This is a new one. This is a new one. So, a fully remote company under 50 employees. A California-based employee reached out to me yesterday to notify me she would be taking leave immediately. She provided her some California things that we don't need to talk about. But anyway, she has a high-level manager role in our company. Today, we discovered that 2 weeks ago, she had transferred critical documents containing some trade secrets and other sensitive info that she had access to from the co-owner's Google Drive to her own. Additionally, she wiped her Google Drive of critical documents she had collaborated on with team members and transferred them so that they are not recoverable. How do we proceed from here? We've already audited and are able to determine that she took multiple steps to ensure the documentation cannot be retrieved and is in violation of multiple company policies. So from an employment lawyer perspective, what should they do here?
Well, again, this is under Utah law, and we're not talking about California law, but I can just say that in that scenario, even if somebody's on protectable leave, in other words, in Utah, it might be fair FMLA leave, you can still discipline an employee who's on FMLA leave for violating policies. Now, you shouldn't do it in retaliation, but this doesn't sound like a retaliatory attempt. It sounds like, in fact, she may be using the leave to further her ability to exit. And so the answer is you can take discipline. You want to be very careful about it. You want to talk to an attorney while you're doing it so you don't trigger, an indefensible retaliation claim, but you certainly can do stuff to protect yourself, and you can terminate the employee.
It sounds like she's stealing company property.
Right.
So
right. You can, you can do anything to protect it. Just because she's on protected medical leave doesn't mean she can break other policies.
Right. Okay. All right, moving on. Okay, here's the next one. So manager one's wife works at our company. They are in different departments in different buildings. Manager two works in the same building as manager one. Manager two and manager one's wife started having an affair. Okay. Now manager one is requesting both his wife and manager two be terminated for code of ethics. Wants to show us text messages these two are sending during working hours. Nothing in our handbook discusses affairs. Has anyone ever dealt with affairs in the company between employees? I'm not sure how to handle this one.
Well, yeah, there are all kinds of problems. Okay, so this happens all the time. I don't know how many different clients I've gotten similar calls
Wow.
about this kind of stuff. It can be tricky, but this defies a simple answer because I need to know more things. But the answer is this. Generally, if the employee is having the affair, is not having an affair with her own supervisor, okay, there's really not much the employer can do unless the the there is a company policy that may address that issue. Okay. And meaning, like, for instance, some companies say that nobody can be involved with another employee romantically. In those situations, you could enforce that policy. Again, this is in Utah. You would have to be careful about how you did it because you might get some, you could get some gender discrimination, sex discrimination claims. Both employees would have to get in trouble. Both employees would have to suffer similar discipline. Again, assuming all things being equal. However, sometimes, and this happens, I've had clients who contacted me because a spouse who doesn't work for the company calls or texts or emails and says, "Hey, my husband, my wife is having an affair with so and so there. And I don't think you should employ those kinds of people. And here, take care of it." It's like they're asking the employer to become the divorce attorney.
Right.
Anyway, and um, you just you shouldn't get involved in that stuff. Um, if the employee is doing things that are harming the company and it's against the policy, then you can take measures. Um, and you just it's very fraught with difficulty, and it's something that defies an easy answer without knowing more.
All right. Okay. Last one. Ready? Our leadership. Okay. I am not sure if my feelings are wrong, but I would love your opinion. Historically, our company has always put the human in human resources. Very generous and understanding if there is an unfortunate circumstance. Our leadership team has changed dramatically. This is my first experience where I see that mindset shift. We have an employee whose last day is this Friday. She is expecting a baby next week and will start her maternity leave. On Sunday, there was an accident and her fiance was shot and is now in the ICU. On top of that, they had to move out of their home this week. She does not have enough PTO to cover her time for this week. So my proposal was to use 2 of her floating holidays this week, her remaining PTO of 10 hours, and then our company would cover the remaining 14 hours. That way she does not have to use her child bonding prematurely, go unpaid, or go in the negative with her PTO. Her manager and my new manager both disagreed and said the company would not cover any variance. She is not a star employee, and they noted that. However, in such a tragedy, I cannot wrap my head around being so strict with this policy. Am I wrong for thinking this way? Are they correct to not vary from policy?
Well, there's a lot of in that as well, and the answer is, are they correct? Sure, they're correct. Um, and the reason why they're correct is this. When you make exceptions to rules, then you can subject yourself to later claims of discrimination if you don't make the same exception for other people. Now, um, just because it is tragic doesn't mean that you necessarily have to bend the rules. And the question whether it's correct or not is, I don't think, the right question. Um, with all due respect to the anonymous questioner, because as a matter of correctness, yeah, they're correct. As a matter of, is this something that could be defensible if later there was a discrimination claim because somebody else didn't get the same thing? Sure, it's defensible. So it's equally correct. I mean, it could be, but you would want to, in that circumstance, say, okay, she was supposed to have her child bonding time, as they said, or FMLA leave or whatever it is, was supposed to start, but then, her significant other was in this huge accident, and it was okay for us to allow her to take leave, or use floating holidays to do this. That's totally defensible. it would be easily explainable in a discrimination case. But there's also more that this HR representative may not know about why these managers are making this decision. So either way, you probably would be correct if that's the question. Is that something that's wise? That's a different question. Is it something that I would necessarily, if I were the manager, is that something I would necessarily, is that a position I would necessarily take? I would almost guarantee I would not take that position. I would probably say, yeah, give her the time off. And I don't even know why you asked me,
Yeah.
but that's not everybody. And I don't know what industry it's in. I don't know how critical her role was. I don't know if she had things that
Right.
she had to get done. And so it's just hard to answer.
Yeah. Okay. Well, no, thank you. All right. That wraps it up. Got a lot of good stuff in there. Just under 40
Yes.
minutes. So thank you everybody for watching or listening. Rate us, subscribe, please. Would love to hear what you think, and feel free to send your questions directly to us, and we can get to them in a later episode. We'll be back hopefully a whole lot sooner than we were this time. Thanks for listening. Bye.
Bye.